As trial lawyers, we struggle with the issue of how to handle bad facts in our cases. Should we put the bad fact in first, or should we wait and respond to it after the other side puts it in? If we introduce evidence of the bad fact first, are we conceding that it's material and magnifying the harm? If we were in a room together right now and I asked for a show of hands for those of you who believe more times than not, you as the trial lawyer dealing with the bad fact that's going to be introduced against you should put it in first, most of you would raise your hands and say that's the best approach generally. Some of you would have a concern and say that, well, it depends upon the case, and in some circumstances at least, you should wait and respond to the bad fact after the other side introduces it. Why do we have these firmly held beliefs about how to deal with bad facts? Are they based on empirical testing? Are they based on studies? Or are they really based more on dogma? Generations of trial lawyers have handed down these thoughts and these ideas around the water cooler, and that is how we've been trained to handle bad facts. But once we study the empirical numbers, maybe inoculation is not the best way, or at least it's not the best way as often as we've been trained that it's the best way to deal with bad facts. That's what today we are going to explore together. What kind of mindset, let's begin with this, what kind of mindset are we dealing with when we confront that jury? When we first stand in front of them, we begin picking our jurors in our case. We're dealing with a mindset of the wrong stuff. Let's talk about the wrong stuff. What book is this from? See if you know. He crashed and was burned beyond recognition, but he should have known better than to wait so long before lowering the flaps. He nosed over and drove straight into Chesapeake Bay. How could anybody be in such poor condition as to pass out that quickly from hypoxia? There are no accidents and no fatal flaws in the machines. There are only pilots with the wrong stuff. Well, of course, that quote is from Tom Wolfe's book, The Right Stuff, about test pilots in the 60s and the 1950s who later went on to become astronauts, many of them. And it captures the mindset that blind fate can't kill me. If I'm following the rules, if I'm doing what I'm supposed to be doing, I'm not arbitrarily going to be struck down by fate. It's a very comforting thought. And the question arises, why were Tom Wolfe's test pilots so unsympathetic to their fellow test pilots who were often killed in crashes of these experimental planes in the 1950s and 1960s? Why were they so uncaring, or apparently uncaring? Well, it raises the issue of the just world hypothesis. More about that in a minute. We can't always control who the client is and who the star witness is. From the plaintiff's point of view, we are supposed to be able to determine who to sign up and not. We are supposed to be able to say no. The issue is this, however. We sometimes have very deserving clients who have either a bad fact in their own past, it might be a criminal record or some other issue, or their case has a bad fact, but nevertheless their case and that client is meritorious, is deserving of representation down at the courthouse. Here is a great quote from a 1950s Texas case that really captures the idea. It is an old rule and a good rule that it is the duty of the trial court to try the lawsuit and not the individual litigant, for it has been said many times, a good person, or rather a bad person, may have a good lawsuit. And I don't think there's a quote that captures the idea better than that quote. A bad person may, in fact, have a good lawsuit, a quote-unquote bad person. The just world hypothesis goes like this. In a just world, bad things don't happen to good people. It's a comforting thought. It's what we and our jurors want to believe, because the alternative means that if we're following the rules, if I'm obeying the traffic lights, I still can get struck down arbitrarily in an unjust way. That's very uncomfortable, that kind of thought to me, and it's very uncomfortable to the jurors. We all want to believe if we follow the rules, if we're good people, and we're doing good things, that we're not going to be struck down arbitrarily. And that's the so-called just world hypothesis, and it's very important that we as trial lawyers are cognizant of it, because it can skew the way the jurors view the world. How do jurors protect the belief in the just world hypothesis? They do it through defensive attribution. How do we all protect the belief in the just world? We do it through defensive attribution. We do it when we're reading the newspaper and we hear about someone who was murdered late at night, and it's uncomfortable, and we think, wow, that could be me maybe. But then we start asking questions that give us comfort, such as, well, what was he doing out in that part of town so late at night? Or maybe there's an untold story that's not referenced in this news article. This was a drug deal gone bad. This wasn't some random innocent person gunned down. That's what we want to believe. And we find ourselves making those kinds of excuses, attributing blame to the victim, essentially, as we read newspaper stories about bad things happening to good people. So what is defensive attribution? It's attributing blame to the victim in order to create psychological distance between us and the fate of a similar fate that victim, what happened to that victim. And so if we believe that that victim did something to cause the injury, if we can convince ourselves of that, if the jurors can convince themselves of that, then it preserves the continuing belief in that just world hypothesis, namely that in a just world, bad things don't happen to good people. Why do we do that? Why do we attribute blame to the victim through defensive attribution? Well, it gives us comfort, as I've said, because it creates distance so that we don't believe, we're not discomforted by the idea that something similar could happen to us or our loved ones, but it also removes the so-called cognitive dissonance. What is a cognitive dissonance? Well, it's cognitive because it's in your brain. It's a dissonance because it's a clash. And the dissonance is created between the just world hypothesis, namely that if you're doing the right things, bad things won't happen to you, and if you're sitting on the jury, this innocent victim that's sitting there as the plaintiff. That creates a dissonance. If that victim truly is innocent, then it's creating a dissonance between the innocence of that victim and something bad having happened to that victim who's in the wheelchair or horribly burned or disfigured, and the just world hypothesis. That hypothesis that we and the jurors, more specifically, all want and need to believe in. And so that dissonance is in our brains. It's a clash between an innocent victim and the just world hypothesis. And when we tear down that victim, if we're on the jury, when we reinterpret the incident as victim caused, when we minimize the injury in some way, then we're going in the direction of removing the dissonance. The human brain is very powerful. We're motivated to do that, to remove the dissonance. And we're able to do that by rewriting, if we're on the jury, in our brains what happened to that victim and why it happened to the victim. And that's a very important phenomenon that trial lawyers need to be aware of. So, what have we done if we're on the jury and we have eliminated the cognitive dissonance through reinterpreting the injury or the incident as victim caused, or by minimizing the injury? We've essentially put our heads in the sand. Psychologically, we have put our collective heads in the sand if we're on that jury, and we've removed our sensibilities. We've put distance between ourselves and that victim by reinterpreting what occurred. That's what we've done. It's a very important phenomenon that needs to be understood. Another phenomenon that needs to be understood is the so-called identification effect. The identification effect. Many trial lawyers believe that jurors who are similar to the plaintiff or similar to the defendant will be more likely to identify with that plaintiff or that defendant and more likely to be sympathetic to that plaintiff or to that defendant. So we are using this belief, many of us, when we pick our juries. We are looking for jurors who are similar to the plaintiff or similar to the plaintiff, and all things being equal, we are defaulting, many of us, towards choosing those jurors and putting them on our jury. Because we believe, rightly or wrongly, that those jurors, all things being equal, are going to be more sympathetic to the party we represent if they're similar to the party we represent. But does that belief withstand scrutiny? Is it really true that jurors who are similar to the plaintiff or similar to the defendant are going to identify more with them? Well, and if they identify more with them, are they going to be more sympathetic? It's really a two-step analysis. It is true, the research has shown, that jurors who are similar to a party tend to identify more with that party. But the second part of the assumption that we all make, namely that because they identify more with that party, they're going to be sympathetic, does not withstand scrutiny. It does not withstand scrutiny. They've done case studies that show that paradoxically, jurors who are similar to the plaintiff, for example, tend to place more blame, not less blame, on the plaintiff, all things being equal. For example, there was a case study involving a young child who was injured in a store. You would think that mothers of other young children would be most sympathetic to that mother and to that family, the mother of the child who was injured. But the study showed that, contrary to that belief, the jurors who tended to place most blame on the mother of that injured child were other mothers with young children. Why? Why would that be true? It would be true because if mothers of young children sitting on that jury believed that arbitrarily, randomly, just by happenstance of fate, a child can get injured in a store, even though the mother of that child is paying full and careful attention to the child, even though the child is not engaging in horseplay, then that is a very discomforting thought to those mothers on the jury. So they need to believe, psychologically, many of them at least, that the mother of that injured child must not have been watching that child as carefully as the mother of the injured child should have been. That's a comforting belief to the mothers on the jury because it preserves their belief in the just world hypothesis. It preserves their belief that bad things don't happen to good people. And if something bad happened to that child in the store, the child must have been engaging in horseplay, or the mother of that child must not have been watching the child as carefully as the mother of the child should have been watching the child. That's a comforting belief. Likewise, they've done case studies where a worker was injured for not wearing a safety belt. You would think that workers, and particularly workers who didn't always wear their safety equipment, would be most sympathetic to the injured worker, the injured plaintiff. That was not true, the case study showed. In fact, some of the most critical jurors of the worker who did not wear safety equipment were jurors who themselves conceded that they didn't always wear their safety equipment. And yet, they were some of the most critical jurors of that plaintiff who was not wearing his safety equipment. Why? Again, defensive attribution, to preserve the belief in the just world hypothesis. Because if a worker could get randomly injured simply by forgetting or by failing to wear a back belt, for instance, that's very discomforting. That could be very discomforting to a juror who sometimes always didn't wear the safety equipment, the proper safety equipment. What about sexual harassment cases? Those have been in the news a lot lately. Studies have shown that, again, paradoxically, some of the most critical jurors of sexual assault victims are jurors who themselves have been assaulted or harassed. Those jurors who themselves have been assaulted or harassed, are more likely, all things being equal, to speculate about whether the assaulter and the person who assaulted the victim had some consensual relationship before, for example. Whether there truly was consent. Whether the victim could have and should have spoken out earlier or more loudly, for instance. That runs contrary to what many at least believe. Again, I would suggest to you defensive attribution. Defensive attribution. Now, what about jurors who suffered similar injuries to the plaintiff? Does the pattern pertain there? Studies have shown that it does. There's a RAND study that showed over 90% of people who were injured took no steps whatsoever to pursue any legal claims arising out of those injuries. And so the implication is this. In any jury that is being chosen, there is a large pool of potential jurors sitting in the panel who themselves were injured but took no steps to pursue legal claims. And so, buyer beware. Lawyers choosing jurors and choosing juries need to beware that those jurors who themselves were injured are potentially prone to engage in defensive attribution, are potentially prone to place more blame on this plaintiff because those jurors did not pursue legal action themselves when they were injured. So the bottom line in the identification effect studies, and that flows from the identification effect studies, is this. In any potential pool of jurors, there are jurors sitting out there on the panel potential jurors on that panel who are similar to the plaintiff, similar to the defendant. The lawyers choosing juries need to be aware that those jurors who are similar will not necessarily give the party they are similar to a pass. And in fact, paradoxically, they may be more prone, not less prone, to blame that party than jurors who are not similar to the party, all things being equal. Let's talk now about another effect, the severity effect. The severity effect has shown is as follows. As the severity of the damages to the plaintiff go up, all things being equal, the jurors need to blame that plaintiff goes up. In other words, victim blameworthiness isn't changing as the studies go along, but the effect, the severity of the damage to the plaintiff is being manipulated upwards. As the severity to the plaintiff of the damages goes up, the need for those jurors to blame that plaintiff goes up. Let's explore that for a minute. The studies manipulated two things, outcome severity and victim blameworthiness. How did they manipulate outcome severity? It might be, for example, in one scenario that Quentin is bruised in the explosion. In another scenario, Quentin is killed in the explosion. Quentin's actions aren't changing, but the outcome severity is being manipulated. So that was how outcome severity was being manipulated. How was victim blameworthiness manipulated? In some scenarios, Quentin's trying to cross when there's a red light. In some scenarios, Quentin's trying to cross and is crossing when there's a green light. That, among other ways, was how victim blameworthiness was manipulated in these studies. So what did the studies show? Well, the studies showed that all things being equal, mock jurors blamed the victim more when outcome severity went up, when that victim was damaged and injured more severely. That's counterintuitive. The studies also showed that all things being equal, victims were blamed more by mock jurors when the victims were more blameworthy. Well, that's logical, and that's what we expect. If I'm more blameworthy and the jurors are following the jury charge, they should place more blame on me when I'm more blameworthy. But the amount of blame the jurors place on me, the victim, should not change if my actions haven't changed, simply because the outcome severity changes, namely simply because I'm injured more, all things being equal. If my blameworthiness remains unchanged, then they should blame me to the same degree, regardless of whether I'm killed or whether I'm bruised. That's what should be occurring, but that's not at all what occurred. So what happened and what the juror researchers determined was that jurors did not focus exclusively on victim blameworthiness in assigning blame. That's what they should be focusing on, but they focused on victim blameworthiness and outcome severity. Why? One explanation is that jurors used so-called hindsight bias. Hindsight bias. In other words, they knew in the scenario that Quentin was going to die because he's crossing on the red light or crossing on the yellow light. They knew that. And with their hindsight, they're attributing that knowledge to Quentin. Quentin's crossing on a yellow, which many people do, and yet Quentin is thinking he may make it. Many people do that, and many people cross on yellows and make it across the intersection. But they know Quentin didn't make it. They know that Quentin in the scenario was killed. So with hindsight bias, they are attributing that knowledge to Quentin, and they're holding him more blameworthy when he is killed, as though Quentin knew he was going to be killed. Quentin, however, didn't necessarily know that he was going to die when he crossed on the yellow. But the mock jurors, with hindsight bias, are attributing that knowledge to him, so says one theory, and they're holding him more blameworthy when he's killed than when he's doing the same thing, crossing on the yellow, and he makes it across, or crossing on the yellow and simply bumped by the car, for instance. So what's the bottom line on defensive attribution? The bottom line is this. Defensive attribution is just one of the psychological games, psychological processes going on back in the jury deliberation room. It oftentimes plays and goes against the plaintiff. But there are other biases as well. There are some biases in the jury deliberation room that go against defendants. There are some biases that help the plaintiff. So defensive attribution, I'm not here today to say it's the only bias and it explains everything the jurors are doing back in the jury deliberation room. It's not the only bias, and it doesn't explain everything they're doing. Neil Feigenson, a jury researcher at Yale, who's also focused extensively on blame. Why do jurors blame certain parties and under what circumstances? Has written a series of articles and books. And he, I believe, has captured it better than most when he says that jurors strive for justice in 5 holistic senses. They try to balance all loose ends between the litigants. That's one of the things they do. They try to use all information, even information that's not admissible. They may be told not to consider something, or they may see something that wasn't explicitly put into the record, but they use everything at their fingertips, everything within their senses. They don't limit themselves in what they do. They make intuitive, holistic decisions. Rather than following strictly what the jury charge says, and rather than strictly letting the charge lead them to a conclusion, they make intuitive, holistic decisions about where they want to go. They want to appear open to persuasion. They want to believe that they were open to persuasion, even if they really weren't. And they gravitate towards decisions that make them feel good. They don't want to leave the jury deliberation room and tell their friends and family, we did this because the charge and the evidence required it, but we really didn't feel good about it. They want to avoid that outcome if at all possible. So one of the ways they can do that is by going in a certain direction and going towards a certain outcome intuitively, but rationalizing later that the evidence and the charge led them there in a very logical fashion, regardless of whether that's really what occurred to get them to their verdict. And we've seen that occur. Anybody who's tried more than a couple of cases has seen that, has heard jurors talk about a verdict after the fact, where they're talking about the verdict and how they got there in such a way that the lawyers know and or strongly suspect that the jurors didn't really strictly follow that charge. They went where they wanted to go intuitively. They went where they wanted to go to balance loose ends and to feel good about that verdict. That's where the jurors went. We've all seen that occur. So, we've talked about inoculating against bad facts. We've talked about what kind of mindset you're facing when you step in front of the jury. But now we need to talk about how best to deal with those bad facts. What strategies work and what strategies don't work. We've talked about the dichotomy between those, which would be the majority, who believe that putting the bad fact in first generally is the best strategy, rather than waiting until the other side puts it in and only dealing with it then. But does that idea withstand scrutiny? Is it truly the fact that, generally speaking, it's best to put the bad fact in first? Well, let's begin with this idea. Dealing with bad facts is not a new problem for trial lawyers. What trial lawyer said this? You'll have to look for another lawyer to handle the case because the whole time I was up there talking to the jury, I'd be thinking, you're a liar and I just might forget myself and say it out loud. What trial lawyer said that? The trial lawyer who said that was a trial lawyer named Abraham Lincoln in the 1850s. That's the trial lawyer who said that. Now, I don't care how good you think your case is when it walks in the door, every single case has landmines. Every single case has bad facts. There's something in that case that you would change if you could. There's some fact you're going to have to get around. You may not have appreciated it at the outside of the case. It may have only begun and become a bad fact after, for example, one of your experts testified and made concessions that you wish they had not made. Concessions that you thought you had gotten the other side to concede were violations of standards of care, but your expert then gives a deposition, for example, and says, no, I don't believe those are violations of standard of care. Or at my company, or in my hospital, we didn't do those things either. Those same things that the plaintiff has been beating up on the defendant about, we didn't do them and we don't do them in my institution either. That may occur in a case, as it did for me in a case once. So how are you going to deal with those bad facts? And by the way, if you have a case on your docket right now that doesn't have any bad facts in it whatsoever, please call me. Please seek me out because I want to work on that case with you. I'll be your legal assistant and work on that case with you if you truly have a case that has zero bad facts in it. I don't care how good you think the case is. Every case on your docket is going to have some bad facts in it. So the only question is this. How are you going to deal with those bad facts? What's the best way to deal with those bad facts to minimize the harm they can do you in the eyes of the jurors? Every case has bad facts. It may be damaging concessions, damaging admissions, violations of policies and procedures, something in that case. It may have been contributory negligence on the part of the plaintiff. It may have been something the defendant conceded. Yes, our policies required us to do this, but we did not. Every case has bad facts. Think about this. If you think your case doesn't have any criminal issue in it, your civil case, probably you need to think again because statistics have shown that 1 in 37 adults has done prison time. It's a staggering number of adults, 1 in 37. So sign up 37 clients. Take 37 depositions. Hire 37 experts. I unknowingly once hired an expert with a felony conviction. I didn't find out till much later in the case. That expert ended up being de-designated, and I got to pay air travel and attorney's fees for the opposing attorney who came to depose the expert before the expert was de-designated. So every case, and more often than not, your case may have a criminal record in it. Every case has bad facts, and look for those criminal records in your witnesses and in the opponent's witnesses because they're there more often than you may think. Now, the fears of the jurors are a big part in how they interpret all facts in your case, and specifically the bad facts in your case, because those bad facts are viewed through the prism of the jurors' fears in the world generally, fears as they relate to your case and to your bad facts. But how rational are those jurors' fears? The fears can play in favor of the plaintiff, for example, in the so-called reptilian theory, the theory of the reptile that's been written about and spoken about generally over the last numbers of years. To the extent the jurors have fears that something similar could happen to them or similar to happen to their family members or within their community as to what the defendant did in your case, that can work in favor of the plaintiff in a given case. But likewise, as we've now discussed, when it comes to defensive attribution, the fear on the part of the jurors that a similar fate could befall them or their loved ones, even if they're following all the rules, that may work against the plaintiff in a given case. The fears arising out of defensive attribution. So the fears cut both ways. But how rational are those fears? Well, there's a generalized fear of crime. There's a generalized perception that crime is going up. Crime rates are skyrocketing. Crime's out of control. The reality is, though, in the past decade or so, crime rates are down. Crime rates are down, not up. There's a fear of flying that many have. Many people fear crashing in an airplane. The statistics, however, show that you're much more likely to die traveling in an automobile than flying in an airplane. If you want to get from point A to B, you're much safer, all things being equal, flying in an airplane than you are traveling in a vehicle on the highway. And then lastly, people fear shark bites. Think about that. Shark bites are terrifying. People fear being bitten by sharks. But the statistics show you're much, much more likely. Millions of dog bites every year, a bare handful, relatively speaking, of shark bites every year. So you're much more likely, if you're going to be attacked by a shark or a dog, to be attacked by a dog, not a shark. And yet, the fear of shark bites outweighs greatly, generally, the fear of being bitten by a dog. So we know, just through the casual empiricism of what I've discussed with you about flying in airplanes, the crime rate, and shark bites and dog bites, that our fears, all of our fears, are not necessarily rational. They're not necessarily based on objective evidence. A researcher named David Ropick has done a study of his so-called fear factors. And the fear factors, as Ropick outlines them in his book is How Risky Is It Really, are as follows. The first fear factor is trust. Do we trust the people or the organizations involved? For instance, in fen-phen litigation, in the pharmaceutical products litigation arising out of fen-phen, jury consultants and others determined that the more the jurors trusted the FDA to objectively and fairly police the manufacturers of the pharmaceuticals, the less likely they were to find those manufacturers responsible for injuries caused by the use of fen-phen. But to the extent the jurors understood that the FDA relies on self-reporting of pharmaceutical companies, and that the FDA is traditionally understaffed, and they can't police everybody everywhere, when the jurors began to understand those facts, then their trust of the FDA, their deference to the FDA went down, and they were more likely to consider holding a pharmaceutical company liable. Another fear factor is risk. Risk versus benefit. The benefit of aspirin is well understood, yet some people every year die from aspirin. So to the extent it's understood that aspirin is beneficial, we are more likely to not hold any company or any entity responsible for any risks associated for aspirin. The generalized perception is that the benefits of aspirin outweigh any risks of aspirin, even though we know to a certainty a certain number of people are going to die every year from taking aspirin. But the idea of holding a manufacturer of aspirin responsible for aspirin as a defective, unreasonably dangerous product is a difficult idea to sell and to grasp, and that would be a difficult sale to make to any jury because of the understanding that there are great benefits to aspirin, for example. Control. Control is another risk factor, or fear factor, more specifically. The degree to which we feel we are in control, as that goes up, we are less likely to fear the issue or the item that we're considering. So if we feel we're in control of it, for instance, if we are under anesthesia and we're being operated on, we're not in control, are we? We are unconscious. We are not in control, so that is a fearful experience to us, all things being equal, versus a situation where we're conscious and we're in control. Another fear factor is choice. The more choice we have in the matter, the less likely we are to fear it. Was the surgery an emergency surgery that we had no choice about, or was it an elective surgery? I'll tell you, in a case where I was picking a jury in an elective surgery situation, it became very clear that the jurors were going to hold the doctor to a lower standard in the case and to be less fearful of the circumstances they were going to be hearing about because my client, the plaintiff, had elected to have the surgery. Shouldn't have made any difference whether the standard of care was met, whether the surgery was elective or emergency surgery, but it became clear to me during jury selection and later that the jurors were holding the surgeon to a different standard because it was an elective surgery. Natural or man-made, that's another fear factor. If it is a natural risk, we are less likely to fear it versus a man-made risk, all things being equal. Man-made risks, all things being equal, are going to be feared more than naturally occurring risks. Uncertainty of the risk. If we're not sure whether it's risky, or we're not sure, there's uncertainty about the entity that could be causing harm, the more uncertain we are, all things being equal, the more fearful we are, and the greater the risk in our mind, all things being equal. Catastrophic versus chronic. Catastrophic risks, a 737 crashing and everyone on board dying. That's catastrophic. Chronic risks would be risks that occur all day, every day. Heart disease, cancer. Those are chronic risks. The truth is, heart disease, cancer kill more people every year than plane crashes. And yet, we fear plane crashes much more, all things being equal, than a catastrophic risk such as heart disease, cancer. Because why? It's a catastrophic, one-time or limited time event, splashes across the front pages of the newspaper, gets our attention, and it's sudden, many people dying at once. It's a catastrophic risk, so we're fearful of it, all things being equal. Can it happen to me? Another fear factor, can it happen to me? If the answer is that I believe and I perceive, sitting on that jury, that this could happen to me, all things being equal, I'm going to be more fearful of it. I'm going to be more inclined to want to take some action to police it, to find against the creator of that risk, all things being equal, if I believe it can happen to me. Is it a new or a familiar risk? All things being equal, familiar risks, even though they may be great risks to me and to my family, all things being equal, familiar risks are not perceived to be as risky to me, and I'm not going to be as inclined to be fearful of a risk I'm familiar with versus one that's a new risk that I'm not familiar with, all things being equal. Risk to children versus risk to adult. If the perception is that children are at risk, same injury, but children are the recipients, children are the potential or actual victims of that risk, all things being equal, I'm going to be more fearful of that risk. I'm going to be more inclined to take action if the victims of that risk, the potential victims of that risk, are children versus adults. Personification is another fear factor. The degree to which I can put faces and names to the victims or those at risk of injury because of the risk, as that goes up, all things being equal, my fear of that risk, my motivation to act, to police that risk, go up. And then the last fear factor, fairness. Fairness. What do I mean by that? Fairness of the risk involves, for instance, case studies where a blind boy is chasing a ball out into the street and is struck down by a car versus a boy who can see. Well, the driver of the car doesn't know whether the child is blind or can see. The driver of the car is not doing anything differently in either one of those two scenarios, hypothetically. Yet, when the driver of that car strikes down a blind boy chasing a ball into the street, all things being equal, it is more unfair in the eyes of those who consider those scenarios, and people are more inclined to be fearful of the situation and more inclined to punish the driver, all things being equal, even though the driver's blameworthiness has not changed in the scenario, in the hypothetical scenario. So, you may say, I'm confused. Why does it matter? Why does it matter whether you use inoculation or sponsorship theory? More about sponsorship theory in a minute. Sponsorship theory is the theory that when you put in bad facts, you're sponsoring them. When you introduce evidence yourself of the bad facts that may be coming in against you, when you preemptively introduce them, you're sponsoring them and you're doing harm to your case. More about that in a minute. Why does any of this matter? Well, whether you were a fan of British Petroleum in the spill and all the damage done, whether you thought British Petroleum was to blame or somewhat to blame for that, British Petroleum's finest moment in that scenario in the news was not when Tony Hayward said, "We've got to put a stop to this spill. I want my life back." When Tony Hayward, the CEO of BP, British Petroleum, uttered those words, British Petroleum's credibility in the court of public opinion took a nosedive. Likewise, how we deal with bad facts in our cases is going to affect our greatest asset in front of the judge and, more importantly, in front of those jurors. How we deal with bad facts affects credibility. Credibility can be outcome determinative in your jury trial. Which party is more credible? Which party handled the bad facts better? Really, it often comes down to that. I'm going to use inoculation today somewhat imprecisely to refer to any theory that says preemptively you, the trial lawyer, should introduce evidence of the bad facts first before the other side does. Sometimes it's been referred to in the literature as taking the sting out of it, lancing the boil, reversing a weakness so that it becomes a strength. It's referred to in various ways in the literature, and there are some technical distinctions between some of the various preemptive theories whereby they don't technically all belong under the umbrella of inoculation. But for simplicity's sake today, I'm going to refer to any theory where preemptively the trial lawyer puts in the bad facts first as just broadly inoculation.
The first code is 117. The first code is 117. The first code is 117.
When and where did the modern study of inoculation begin? Well, it began in the wake of the Korean War. You're looking at a slide for the movie The Manchurian Candidate. In The Manchurian Candidate, Lawrence Harvey had been captured as a Korean War POW, and he had been brainwashed to assassinate the president later when his handler, who actually was his mother, played by Angela Lansbury in the movie, gave him a secret code word. He, against his will, because he had been brainwashed, was then going to assassinate the president. Now, and you see Frank Sinatra is also in the movie poster there. Frank Sinatra was his commanding officer in the Korean War in the movie, and he also had been brainwashed. But he begins to suspect in the movie that something is amiss, that Lawrence Harvey is somehow implicated in some kind of brainwashing or something that went on when they were captives in the Korean War. Interestingly, this movie was coming out into circulation right around the time President Kennedy was assassinated, and it was then withdrawn for a number of years from circulation because of sensitivity about the movie depicting an attempted assassination of a president. What does all this have to do with inoculation? In the wake of the Korean War, in reality, there were Americans who were captured by the Chinese and by the North Koreans, and by the Koreans who were fighting with the Chinese. They weren't yet the North Koreans. And the United States government began concerned that some of those POWs were chucking their allegiance to baseball, hot dog, and apple pie a little more readily than they should have, and they were making recordings, anti-American recordings, when they were captured. And the United States government wanted to determine why that was occurring. Why were these POWs all too readily turning, in essence, some of them, when they were captured? And the United States government determined, in the wake of the Korean War, that these POWs had not been inoculated against the benefits of communism. They had never been told anything positive whatsoever about communism. So when they were captured and they were hearing for the very first time some of the benefits of communism, they were then turning, they were changing their allegiance. They were saying, well, maybe communism isn't so bad. They were hearing for the very first time the benefits of it in the 1950s. And the United States government determined that they had not been, these POWs, inoculated against the benefits. They hadn't heard any of the beneficial aspects, so-called beneficial aspects of communism, from the United States government. And so when they heard them for the first time,
They weren't really fortified against hearing them. They weren't inoculated against those benefits. So, inoculation has also been written about and studied within the reported cases. You're looking at now on your screen some language from a case, Oler versus U.S. Oler versus U.S. And this, the language you're looking at, is from the dissent by David Souter. And in this dissent, Justice Souter wrote, "The jury may feel that in testifying without saying anything about the convictions on direct examination, the defendant has meant to conceal them, and the jury may blame her for not being forthcoming when she seemingly could have been." The issue in Oler, and we'll come back to Oler in a minute, was whether a criminal defendant in Oler was being prosecuted criminally for a drug possession crime, whether she could take the stand and object, make clear that she objected to the admissibility of a previous similar crime, and yet still complain on appeal about the admission of that crime when she inoculated, when she, in response to questions from her lawyer, brought up the criminal conviction first, the previous criminal conviction. More about that in a minute. Who are the proponents of inoculation? Well, one of the proponents, as you see there, is Jerry Spence. Jerry Spence believes and is all about forgiveness. Jerry Spence says that we can be forgiven for a wrongdoing we have confessed to, but when we try to conceal it, the jurors in this case, are not going to be likely to forgive us as readily if they believe we've concealed the wrongdoing. And in this case, the wrongdoing is the bad fact. And so, by implication at least, Jerry Spence, in some of his writings, has condoned inoculation. We talk about the bad fact first before the other side does, and therefore we can be forgiven for that bad fact, so says Jerry Spence. Others who are advocates of inoculation say that by inoculating, we can choose the time and the manner in which the bad fact comes out in the trial. Is the bad fact going to come out just before the jurors go home for the weekend so they can stew about it all weekend? Or is it going to come out in the case right after lunch when they might be a little sleepy after they've heard good facts just before lunch, and right before they start hearing more good facts later in the afternoon? So the timing of when the bad fact is introduced can be very, very important. And when we are inoculating, we can choose that timing. That's an important advantage. Many of the commentators say that we gain by inoculating preemptively. It also shows when we inoculate at least an apparent willingness to lay all the facts out before the jurors. It enhances our most important asset in front of those jurors by showing those jurors we aren't trying to conceal, that we're laying it all out there for those jurors. We're not hiding anything. They heard about it from us first, not from the other side. Jury consultant Donald Vincent has written about inoculation. And first, who is Donald Vincent? Donald Vincent is the jury consultant who offered his services free of charge to O.J.'s first criminal prosecutor, Marcia Clark. She ended up dismissing him and saying she didn't need his help. We know what happened there. O.J. was acquitted. Interestingly, later, Donald Vincent ended up working with O.J.'s jury consultant, and they worked together. That was after the O.J. trial. And so they ended up getting together. But Donald Vincent says that inoculation, for some reason we don't fully understand, spurs the jurors to begin creating self-generated excuses for the bad fact beyond even what the inoculator has introduced into the record. So, for some reason we don't understand, the jurors say, not only is that bad fact not as bad as we think it is because of the mitigating explanation that Brogdon gave when he introduced it, it's also not as bad as we thought it might be for these other reasons that Brogdon didn't even mention. But here are some other reasons we on the jury have thought of as to why this bad fact may not be as bad as Brogdon or the opposing attorney says it is. Also, Vincent notes that, of course, the inoculation is most effective when it is supplemented with the mitigating explanation that the jurors might or might not make on their own. The mitigating explanation as to why the fact is not as bad as it might first appear to be. Now, some proponents caution that you shouldn't reflexively and automatically inoculate against every bad fact in the case. Thomas Mowat has written a trial handbook that many of us used in law school. It's used in a number of law schools across the country. And he says, don't always and reflexively inoculate. You should look at certain factors, and he outlines them. First, how bad is the fact really? Is it a small, minor fact? If so, you might not want to spend time, in essence, dignifying it with a response by inoculating. Does your opponent know about the bad fact? That's another factor that Thomas Mowat says to consider. In this age of wide open discovery, most of our opponents know most all the facts in the case. So generally they already know about this bad fact, but sometimes, even today, in this age of wide open discovery, there are bad facts out there that our opponents don't necessarily know about. If they don't know about it, the bad fact, your opponent, or if your opponent probably doesn't know about it, you might want to hesitate before you inoculate. Another factor that Mowat says to consider is whether you can gracefully inoculate. Do you have to stop and shut down your entire case to divert and detour off the freeway to inoculate? If so, you might want to consider not inoculating if you can't do it gracefully. Another factor to consider is whether the bad fact will be admissible during your direct examination. Depending on your jurisdiction and the rules of the court, it might not be admissible. You might not be able to inoculate even if you want to inoculate it. And then lastly, you might want to consider, Thomas Mowat advises, whether your opponent has the trial skills, whether they have the trial skills to effectively use this bad fact against you. Now that's playing some high-stakes poker if you guess wrong. But if you have relatively inexperienced or ineffective opposing trial counsel against you in the case, you might want to consider risking it, not inoculating, waiting to see how it's used and whether it's used effectively against you before you decide to inoculate. How do you inoculate if you're going to be inoculating? Well, all of the commentators say if you decide to inoculate, do it between strong points. Start strong, inoculate if you must, and then end with a strong point. Sidney Lumet, who wrote the NIDA, National Institute of Trial Advocacy, Hornbook on Trials, he says start strong, inoculate in the middle if you must, and then end strong. Russ Herman, former president of the ATLA, which is now AAJ, American Association of Justice, the plaintiff's trial lawyer group in the country, he says start strong, deal with the weakness if you must, end strong. And then lastly, Thomas Mowat himself in his Hornbook says start strong, inoculate if you must, and then end strong. So the consensus on how you do it is unanimous. Do it between strong points if you're going to inoculate. What you're looking at now on your screen is a real note handed to me by a real client in a real trial. And the lesson of this is tell your client what you're doing if you're going to be inoculating. This note was handed to me after I stood up and gave an opening statement as a plaintiff in a case during which I mentioned some of the weaknesses in the case, weaknesses that involve personally this client. Well, after I did what I thought was an effective opening statement, and in a statement in which I inoculated and practiced what I preached, namely inoculating against some bad facts, as I sat down, my client handed me calmly this handwritten note. And of course, the jurors are looking at me and my client wondering what's in the note. So I'm opening the note and I'm reading it, and the note says, I cannot believe you have managed to lose this case within the first 5 minutes by doing exactly as I asked you not to do so, by terribly mentioning all those things. So needless to say, my client did not appreciate, nor did he understand the inoculation. Well, the jurors are looking at me wondering whether I've gotten an attaboy note or a scolding note or something in between. And of course, I'm looking at my client, smiling and shaking my head as though I've gotten just the biggest attaboy note you can imagine. Okay, yeah, I thought it went well too. and not betraying at all that I'd gotten this scolding note about inoculation. So the moral of the story is, explain to your client what you're doing. Make sure they understand that you haven't switched sides and signed up with the other team, that you are going to have to be inoculating as the case goes along if that's your strategy. Namely, putting in some bad facts doesn't mean you signed up with the other team. So how large is the weight of authority behind inoculation? Well, candidly, it's overwhelming. For every commentator who cautions not to inoculate or beware or do it sparingly, there are 9 or more commentators who say that more times than not, you should inoculate. So why am I spending time during this talk discussing the dichotomy between a strategy of inoculation versus a strategy of so-called sponsorship? I want to talk to you for a minute here now about the sponsorship theory, the so-called sponsorship theory. I alluded to it earlier. It derives its name from the idea that when you put in evidence yourself, you're sponsoring it. And what does that mean? It means that every bit of evidence, according to this theory, that you introduce, the jurors are presuming that you concede its material, number one. And number two, any harmful aspect, any harmful nature in that evidence is being magnified by the fact that you're putting it into evidence. So when you sponsor evidence, according to the sponsorship theory, 2 things are happening. You're conceding that it's material, number one. And number two, you're magnifying any harm that is within that evidence. So where does the sponsorship theory originate? It originates in the year 1990. 2 U.S. attorneys, Klonoff and Colby, wrote a book entitled Sponsorship Strategy, Evidentiary Tactics for Winning Jury Trials. And in that book, they said essentially that the conventional wisdom of inoculation in dealing with bad facts is unsupported dogma. That it's been repeated year after year, that it's not supported by any empirical testing, namely any testing involving numbers and studies and strategies, that it's just dogma. And that we are conceding evidence as material and magnifying the harm when we introduce it, and we should hesitate. In fairness to Klonoff and Colby, they did not say you should never inoculate. I know that's a double negative. But they don't advocate failing to inoculate in all circumstances. They say you should inoculate, particularly in those situations where you have what they call party-associated evidence. What is party-associated evidence? Party-associated evidence is evidence that you as a party have unique control or custody over it in some manner. And so in that circumstance, it's a witness who's employed by you, for instance, who knows or has testified in some damning way, or maybe your own expert. In those types of circumstances, in some situations, they say you should consider inoculating, putting it in first, because in those circumstances where it is party-associated evidence, the jurors may indeed penalize you for failing to inoculate. But, as a general proposition, Klonoff and Colby say, do not reflexively inoculate. Do not walk around in fear of the other party putting it in first. And there were 3 main lessons of the sponsorship theory. The first lesson is don't walk around in fear of the other party putting in the evidence first. Don't be so afraid that they're going to put it in first, that we all are way too afraid of that. The second lesson was to sponsor even favorable evidence only if the benefits outweigh the costs. Sponsor even favorable evidence only if the benefits outweigh the costs. And then lastly, that the parties should be engaging in this, in essence, this game, this strategy where they're trying to shift the costs of admitting evidence to the other side. In essence, they say, Klonoff and Colby, that there's this algebraic equation involving benefits versus costs. What are the costs of admitting evidence? Well, the costs are that you're conceding its material when you admit it, and you're magnifying any harm that's within the evidence. So they're saying look at every piece of evidence in your case through that prism and try to shift the costs, namely the concession of materiality, the harm that's within that evidence, the harm that it may do either party, onto the other side when appropriate. That's what Klonoff and Colby say. And Klonoff and Colby in general say that this idea that seems to buttress inoculation, namely that the parties are going to penalize the jurors are going to penalize the party that does not inoculate, is a fallacious idea. That the jurors are too smart in this day and age, that they know and they expect the attorneys to be, in essence, hired guns, to put on the best case that that attorney can for the party that hired them. The jurors don't expect the parties to be introducing equal measures of good and bad evidence. The jurors expect the parties to be putting in the best evidence that there is available for the attorney's clients. And they're not going to reward those jurors, are not going to reward the attorneys for putting in both sides of the case. They don't expect that, and they're not going to reward it. That's what Klonoff and Colby said. So, at this juncture, you may say, well, there are two theories. There's an inoculation theory, and there's a sponsorship theory. Which theory is the best theory generally? And has there been any testing done to compare the relative merits of the two theories, inoculation versus sponsorship? So let's talk now about some of the empirical data. The empirical data assessing the relative strengths of the inoculation theory versus the sponsorship theory. The first study that I want to talk to you about is a study done by two jury consultants in 1993, the Rice-Leggett study. The Rice-Leggett study involved a hypothetical crashworthiness case, a products liability case involving an automobile. And the bad fact for the plaintiff in that case was that the plaintiff had alcohol in his blood according to the autopsy results. Needless to say, if you represent the plaintiff in a crashworthiness case, your plaintiff was driving an automobile and the autopsy confirms alcohol in the plaintiff's blood, that's a bad fact for you. There were two groups of 75 jury-eligible adults. What that probably means is there were two groups of 75 grad students who were in psychology who had no real choice but to participate in the study. In any event, how was the study set up? The study was set up so that each group saw videotaped opening statements. The sponsorship group saw a defense attorney who made full use of the drinking. So the defense attorney said that the defendant in that case believed that the product was not defective and, further, that the plaintiff had been drinking alcohol. Both groups actually saw that defense attorney doing the same videotape statement, the inoculation group and the sponsorship group. The sponsorship group saw a plaintiff's attorney who made no mention of the drinking. So the first time the sponsorship group heard about the drinking was from the mouth of the defense attorney. The inoculation group, on the other hand, saw that same plaintiff's attorney on videotape, but that plaintiff's attorney mentioned the drinking first. So the inoculation group heard about the drinking from the plaintiff's attorney first. The plaintiff's attorney mentioned the drinking, but then offered the immediate mitigating explanation. The mitigating explanation in the case was that the amount of alcohol in the plaintiff's blood did not exceed the legal limit for intoxication in that jurisdiction. Furthermore, that the plaintiff did not have a reputation as a drunk. Those were the two mitigating explanations that the inoculating attorney offered in the videotaped opening statement. So, again, the inoculation group in this study heard about the drinking first from the plaintiff's attorney. The plaintiff's attorney offered the mitigating explanation. The sponsorship group, on the other hand, did not hear about the drinking until the defense attorney made the opening statement, and that's when they first heard it. So, what happened? How did it shake out? How did those mock jurors perceive the attorneys and their arguments? Well, the inoculation group perceived the plaintiff's attorney who inoculated to be more honest, poised, persuasive, and effective than the sponsorship group perceived that same plaintiff's attorney to be. So it's the same plaintiff's attorney doing two different opening statements. So when that plaintiff's attorney inoculates versus when the plaintiff's attorney does not inoculate, the plaintiff's attorney is more honest, persuasive, poised, and effective than the plaintiff's attorney, same plaintiff's attorney, who does not inoculate. Now what about the defense attorney? This is the most interesting thing. Remember, both groups saw the same defense attorney during the same opening statement. It's just that the sponsorship group saw that defense attorney mention drinking. That was the first time they heard about drinking. Whereas the inoculation group, when that defense attorney mentioned drinking, the inoculation group had already heard about it from the plaintiff's attorney. Well, not only did the plaintiff's attorney get a kick up, a boost in being honest, persuasive, poised, and effective when that attorney inoculated, but when the defense attorney faced the inoculating plaintiff's attorney, remember it's the same defense attorney during the same opening statement, that defense attorney was less honest, less poised, less persuasive, less effective, and more nervous in the eyes of the sponsorship group. So than he was in the eyes of the inoculation group. So not only did the inoculating attorney get a benefit by inoculating, the defense attorney who faced an inoculating plaintiff's attorney got a kick down, suffered a detriment in persuasiveness, in poisedness, in effectiveness, when that same defense attorney during the same opening statement faced an inoculating plaintiff's attorney. That's pretty powerful stuff. You may ask, who won more often? Well, it wasn't a huge margin, but the inoculation group won 50% of the time, whereas the sponsorship group, where the plaintiff's attorney did not inoculate, won only 43% of the time. Not a huge margin, but on any given day, if you're within that 7% where you win more often, it could be outcome determinative, needless to say. So, what does this study show? It shows that inoculators are perceived in a more favorable light in the eyes of jurors. It shows that their arguments are more effective. It shows that those who face inoculators, their arguments are not as effective. It shows that jurors are more committed to the side that inoculates, all things being equal. Now you may say, what response, if any, did Klonoff and Colby have to, for example, this Rice-Leggett study? Well, they had a specific response to it in an article in the year 2000 published in the Texas Bar Journal, in response to an article I wrote where I outlined and discussed the Rice-Leggett study from 7 years before. In their response, Klonoff and Colby said that the Rice-Leggett study was flawed, that it set up, in essence, what they referred to as an easily toppled straw man. Why did they say that? They said because it was not a realistic scenario. They said because in real life, for example, the sponsorship attorney would have been able to make the inoculator pay a price for the inoculation. How so? Well, the sponsorship attorney would have been able to say, you heard that the inoculator mentioned this fact first. Obviously, the inoculator thought that was a very important fact. And so in that way, among others, the sponsorship attorney could have made the inoculator pay a price. And because the Rice-Leggett study did not have that back and forth dynamic built into the study, Klonoff and Colby say that in among other ways, the study was flawed. They also pointed out that they do not always recommend, as some, they say simplistically have said, that inoculation is the best way to deal with bad facts. They pointed out in their article in the year 2000 that they had argued and advocated in their book from 10 years earlier that in some circumstances, including but not limited to those cases involving party-associated evidence, evidence that a party has uniquely within its control, that parties in those cases should consider inoculating. So they say, and they reiterate in their article in 2000, we do not always say inoculate. Now, here's an example of inoculation that's very effective from real life. Domino's Pizza. And before I move to Domino's Pizza, I want to tell you there are other studies within a legal context where inoculation and the benefits of inoculation have been studied and critiqued. There was a series of studies by Williams, Bourgeois, and Kroll. Some of those studies involved criminal convictions. Some of those studies, for example, involved an expert witness on behalf of the plaintiff. In the civil studies involving the expert witness on behalf of the plaintiff, the expert had a bad fact. It was a bad fact to be used against that plaintiff's expert. Namely, the expert was testifying in that case for the plaintiff without the benefit of actually having examined that plaintiff in person. It was a medical expert, a causation expert. Whereas that expert had testified in a previous case that it was very important that the party, the plaintiff, be examined physically before an opinion be rendered. And yet, that's exactly what the party was doing in that case. When the plaintiff inoculated against that bad fact, Williams, Bourgeois, and Kroll found, just as in the study involving the one we just talked about, that the plaintiff did better by inoculating. The plaintiff did best when the jurors didn't even hear about the bad fact. But if the jurors were going to hear about the bad fact involving the expert, the jurors were going to be more forgiving, the plaintiff was going to do better, all things being equal, if the plaintiff mentioned it first, namely if there was inoculation.
The second code is 4,
6, 8,
The second code is 4,
6, 8,
The second code is 4,
6, 8.
Now you may ask whether there's any research other than the Rice-Leggett study and some other studies that were done in the legal context that addresses inoculation in a context outside of the law world. And the answer is yes. There's both casual research that's been done related to marketing, and there have been some articles and discussions done in the context of sales. Namely, if I'm trying to sell you a product, and that product has some bad fact or arguable bad fact, if I'm the first one to disclose that to you, am I going to make more sales of the product versus situations when I'm not the first one to disclose that to you? Here's a real-life scenario ripped from the headlines of the last several years. This scenario involves Domino's Pizza. As many of you may remember, Domino's Pizza ran a series of articles, a series of advertisements a number of years ago where Domino's Pizza began trashing their own pizza. So-called self-flogging ads, where they said the pizza crust tasted like cardboard. They said the sauce tasted like ketchup. Bland pizza, they said it tastes like pizza comes from a microwave. These are not the kinds of things typically companies say about their own product, particularly if they're trying to sell it. Specifically, if you're a pizza company, you're not going to run commercials. It'd be unusual to run commercials where you're touting the bad aspects of your pizza, saying that the crust tastes like cardboard. Well, Domino's had done some studies where they determined that there was a sizable group out there that had concerns about the taste of the pizza, that had some bad feelings about the pizza. So Domino's thought was, let's inoculate. Let's run commercials where we talk about those bad aspects, and then we talk about what we've done to address them. So they ran the commercials where they talked about the bad aspects of the pizza, and then they said, most companies try to hide that. We're not trying to hide it. And furthermore, we've fixed our pizza. We've addressed this. Everything about our pizza is better. The crust is better. The sauce is better. Basically, come try the new Domino's Pizza. That was the gist of the commercials. We know we had a problem before. Here we are. We're not hiding it. Now we've corrected. Now come try the new pizza. So they did that. What happened? What happened is that sales were up almost 17% in the 6 months following those commercials. 17% for a company the size of Domino's Pizza, a company that sells a lot of pizzas. That's a huge increase in sales. That's a dramatic increase. Domino's attributed it not only to the improvement of the product, but to the inoculation that was done in those ads. So that's a real-life example. What about strategies other than inoculation for dealing with bad facts, for dealing with harmful evidence? Well, the first and the preferred strategy is to turn the harmful fact into a strength if you can, to turn the weakness into a strength. So, for instance, from my side of the docket, from the plaintiff's side of the docket, we hear defendants say, well, the plaintiff delayed seeking treatment. The plaintiff did not ask for an ambulance at the scene of the crash. We hear things like that. Well, we can try from the plaintiff's side to turn that weakness into a strength. We can say, well, had this plaintiff had an agenda to file a lawsuit, to pursue a lawsuit agenda, this plaintiff would have been screaming at the top of their lungs from the scene, give me an ambulance. They would have gone immediately to the hospital. They didn't do that because they were toughing it out. They had no agenda to come down to this courtroom to file a lawsuit. But here they are because they ended up having pain, problems, disabilities that they didn't foresee they were going to have. And they certainly didn't have a lawsuit agenda at the outset. So that's an example of trying to take a weakness and turn it into a strength. A second strategy is to file a motion in limine. Depending on what jurisdiction you're in and whether you're in federal court, motions in limine have different significances. Motions in limine accomplish different things. Motions in limine, in my home jurisdiction of Texas, generally preserve no error. I, in my home jurisdiction, must file a pretrial motion for ruling on admissibility. It's got to be styled and treated differently than a limine. It's not done, should not be done, with the jury waiting in the hallway. I've got to be very clear that I'm not invoking a simple garden variety motion in limine. Because in my state, in Texas, when I file a garden variety motion in limine, I'm preserving no error. The ruling granting the limine, namely keeping out the bad evidence without approaching the judge, preserves no error. Likewise, if the judge denies the limine and the evidence is offered, an objection has to be made. An objection has to be made to the bad fact or the bad evidence when it's offered to preserve error. Otherwise, it's like writing in sand on the beach. Washes up on the sand, no error preserved. Now, motions in limine. We've talked about that. Limiting instructions. Limiting instructions. Look at Rule 105 of the Federal Rules of Evidence if you're in federal court, or in your state jurisdiction. Many states, such as mine, have rules of evidence that are patterned after the federal rules. In my jurisdiction, in state court in Texas, for example, we have a Rule 105 that's very similar to the federal rule. The federal Rule 105, in essence, says this: if a bad fact is offered against you and you object and the judge overrules you and is coming into evidence, you probably have a duty under that rule, in the case law interpreting it, to ask the judge to give the jury a limiting instruction, to say that the jury should only consider that bad fact for the limited purpose for which it should be admissible. If you fail to do that, you've probably given up your right to object to the admission of that bad fact on appeal. Likewise, if you're the one offering it and the judge or grants an objection keeping it out, you probably under Rule 105 have a duty to reoffer it with a limiting instruction. That's right. You have a duty, probably under Rule 105, to reoffer the bad fact, to offer your own limiting instruction to say, we're offering it, the jury should consider it only for this specific limited purpose. And if you fail to do that, you've probably given up your right to appeal based on the judge's keeping out the bad fact on appeal. So, those are limiting instructions. So there are two lessons, as I said. If it comes in over your objection, the bad fact, move for a limiting instruction. If you're offering the bad fact and the judge grants the other side's objection, reoffer the bad fact with a limiting instruction. If you fail to do those things, you may have given up your right to appeal based on that bad fact. But let's talk about what I referred to as the Inoculator's Dilemma. What is the Inoculator's Dilemma? The Inoculator's Dilemma is this. Most jurisdictions, and in federal court, you have a duty to timely object to the bad fact. And if you fail to do that, you've given up your right. If you haven't objected on a timely basis at the trial court level, you've given up the right to appeal based on the admission of that bad fact at the appellate court level. So how do you simultaneously satisfy that requirement to make a timely objection and offer the bad fact yourself? Do you say, Judge, I'm offering this bad fact, and I object to the admission of the bad fact? Well, that seems to make no sense. That you're offering the bad fact preemptively, and yet you're objecting. Now, there are two related concepts that are related but distinct here. One is preservation of error. Namely, do you preserve error with your objection on a timely basis at square one? The second related but distinct concept is waiver. Waiver means that I may have preserved my error at square one, but later, usually, I've waived the error by offering, for example, the bad fact myself. So, those concepts are very confusing, and even within the reported opinions, the language of preservation of error is often used inconsistently and intermittently with the language of waiver and imprecisely. So courts themselves seem to be confused on many occasions about the distinction between preservation of error, did I preserve it at square one, versus waiver, did I later waive it? Let's talk now about a very important case. Within the federal circuits, there was a conflict up until the year 2000. So as late as 2000, there was a conflict within the circuits. It depended on what circuit you were in, whether you could preserve error, offer the bad fact preemptively, and still complain on appeal. The case that went up that resolved that conflict was Oler versus U.S. in the year 2000. It was a Rehnquist-authored opinion. It was a close opinion. It was a 5-4 opinion. What were the facts of Oler? In Oler, a woman was charged with a crime, a drug crime. The government said, if you testify, we're going to impeach you. You don't have to testify in a criminal case, but if you do, we're going to move to admit evidence that you previously were convicted of the very same and similar drug crime. She, through her lawyer, filed a pretrial motion for ruling on admissibility. She made it very clear that she objected to the admission of that previous crime. And this is an important point. In Oler versus U.S., the United States Supreme Court spotted her that. They said, you did make clear. You did preserve error pretrial through this pretrial motion for ruling on admissibility. Even though, as I've cautioned, you have to be careful because a garden variety motion in limine in my state court and in many courts will not preserve error. But she threaded the eye of that needle. She filed her pretrial motion for ruling on admissibility, so she preserved error. But when she got to trial, Oler took the stand, and her attorney asked her about the previous conviction before the other side, the state did, the United States government, and she admitted she introduced the evidence through her attorney. On appeal, she complained, and she said she was convicted. On appeal, she said, I made very clear that I did not want this conviction coming in, but I had a dilemma. If I took the stand and defended myself preemptively, I had to put this in because if I didn't, then the jury was going to hear about this previous conviction for the first time from the mouth of the United States government. And Rehnquist said, here, you preserved error. We'll give you that. We'll spot you that. You preserved error through this pretrial motion. But when you took the stand and put it in yourself, you later waived the error. So you preserved error at square one, but later in the trial, you waived error. Yes, we hear you. We hear your argument that it is unfair to force you to choose between either not defending yourself and taking the stand or giving up an appellate point based on the introduction of this previous conviction. However, trials aren't always fair. Everybody has to make strategy decisions at trial, including the government in this case, including you. So it's not so unfair that it requires reversal. So we're not going to reverse your conviction based on the fact you had to make a choice here. So that's Oler versus U.S. As I said, there are two related but distinct issues. We've talked about them. Fail to preserve error and waiver. So in your jurisdiction, which is it? Well, if you're in federal court, Oler versus U.S. is going to control. If you're in federal court, probably, if you put in the bad fact, you've given up the right to appeal based on the admissibility of the fact. Now, in your local jurisdiction, you're going to need to look at what the cases say. You're going to need to look at Rule, 103 is the Texas rule on timely objection. You're going to need to look at your rules of appellate procedure. You're going to need to look at the case law. Consistently, jurisdiction to jurisdiction, there's a requirement that you make a timely objection to a bad fact coming in. Why? The cases consistently say, in order to give the trial court judge the ability to correct it real time. In other words, we're not going to say as an appellate court that we, for the first time, get to look at this if you didn't give the trial court judge the chance to fix this by making a timely objection at the trial court level. So the issue, as I've said, is how can you object and admit it simultaneously? Well, within the Texas cases, in our state court, in my jurisdiction in Texas, the Texas Supreme Court has looked at this. In some cases, for instance, there's a case where a Jehovah's Witness refused a blood transfusion. The Jehovah's Witness was the plaintiff. The court said the court was going to allow this bad fact into evidence that the Jehovah's Witness had refused the blood transfusion. So the plaintiff's attorney stood up during the jury selection and mentions it first, and then later complains based on appeal. Well, the Texas Supreme Court uses interchangeably waiver language and fail to preserve error language. And see, what's interesting about that case involving the Jehovah's Witness is, and that case was Accord versus GM. The Texas Supreme Court, the defense never offered the evidence of the blood transfusion. It was the plaintiff who did preemptively, but then the defendant never did. So the court said, well, you didn't preserve error by objecting. But there was nothing to object to during the trial because the defense attorney never offered it. But then the court also used waiver language in saying there's no reversible error when the court said, you, the plaintiff's attorney, put this into evidence first. So the court, as so many courts do, used interchangeably, inconsistently, arguably, failure to preserve error language and waiver language. There's also a case called Bay Area Healthcare versus McShane from the year 2000 in the Texas Supreme Court. In that case, it was a med-mal case. The plaintiff sued some doctors and then later non-suited them. The plaintiff tried to keep that out of limine, specifically the limine item related to prior superseded pleadings. The court said, no, I'm going to allow those superseded pleadings in. Well, then the court, or the plaintiff's attorney rather, during jury selection mentions the fact that, well, the doctor's acts could have been brought before the jurors, but neither party is doing that here. Well, neither party was doing that at the time of the trial. Nevertheless, the trial court allowed the doctors to say during their direct examinations, may have been redirect, that they had been named as defendants previously in the case over the plaintiff's objection. Well, when it went up to the Texas Supreme Court said, sorry, you, the plaintiff's attorney, you were the first person, and you did this during jury selection, to mention the status, to allude to the status of the doctors when you said the doctor's status could have been brought before you, the jurors, but it's not being brought forward. When you did that, you waived the ability to complain about it based on appeal. And the court cited another previous Texas Supreme Court case in support of that where the intoxication of the plaintiff was at issue, and it was the plaintiff's attorney who first mentioned that intoxication. So, what's the bottom line in dealing with bad facts in your jurisdiction? Well, if you're in federal court, look no further than Oler versus U.S. and its progeny. Probably, if you put it in first, you've given up the right to appeal based on the admissibility of the bad fact. Try motions in limine, or whatever variation your jurisdiction has. Try to get something more permanent than a motion in limine, a pretrial motion for ruling on admissibility, or whatever it's styled in your jurisdiction. Do that. Try to turn the weakness into a strength. But if it's coming in, you may well, in your jurisdiction, be forced with that so-called Inoculator's Dilemma. Do I put it in at the trial court level and give up the right to appeal later? Or do I wait and gamble that it comes in when the defendant puts it in, and maybe I can get a second shot at this by getting the appellate court to overturn this verdict against me based on the admission of that bad fact? It's a dilemma, and there's no easy answer. It's fact-specific, it's case-specific, You're going to have to decide based on your case and the case law and your hunch, in essence, your gut call on how this will shake out in your jurisdiction. Bad facts are in all of our cases. They're never easy to deal with. My hope today is that my talk has given you perhaps a little different way to start considering how to deal with those bad facts. Perhaps a little more scientific approach to how to deal with those bad facts. Perhaps some thought provocation here that may, next time you're dealing with one of those bad facts, help guide you to the best outcome. Good luck in your trials. Good luck in dealing with your bad facts. And thank you for giving me your time and attention today. Thank you.